law, and it's there. And he said the president shall appoint the controller and accountant general in accordance with Article 195 of the Constitution. Okay, and that was the basis for the appointment. And no civil servant is appointed on based on Article 195.
No civil servant is appointed on the basis of Article 195 of the Constitution. Now, if the audio is not that audible, we've transcribed what the Controller and Accountant General said in text. Let's put that on the screen right now. He says, the Controller was appointed by an Act of Parliament, the PFM law. And it says, the President shall appoint the Controller and Accountant General in accordance with Article 195 of the 1992 Constitution. And that was the basis for which the appointment, and no civil servant is appointed based on Article 195 of the 1992 Constitution. That's Kwesi Kwening Bosompem, the Controller and Accountant General there. Professor Ransford Jampo is joined us. Good morning, Prof.
Morning.
Thank you for joining us. So, let's look at the specific laws, right? Start from there for the benefit of our viewers. Let's look at Article 195 of the 1992 Constitution, because there are two things that the Controller makes reference of, two laws, the Article 195 and the PFMA. This is what Article 195, this is the Public Financial Management Act 2016 at 921. It says the President shall, in accordance with Article 195 of the Constitution, appoint a Controller and Accountant General who shall be the Chief Accounting Officer of the government and the Chief Advisor to the Minister, in this case the Finance Minister, and government in matters relating to accountancy. It continues. The terms and conditions of service of a Controller and Accountant General shall be specified in the letter of appointment and shall be appointed for a term of 4 years, which may be renewed for another term of 4 years. So what we do know is that the Controller has actually served the first term of 4 years, and there has been an extension.
Okay.
So it's on contract for an additional 2 years.
Okay.
I think she's beyond the age of 60. 62. Celebrated his 62nd birthday sometime last year.
Okay.
Let's look at the Article 195 of the 1992 Constitution as well. What does it say? 1951 says, subject to the provisions of this Constitution, the power to appoint persons to hold or to act in the office, in an office in the public services, shall vest in the President, acting in accordance with the advice of the Governing Council of the service concerned, the Governing Council of the service concerned, given in consultation with the Public Services Commission. This is what Article 195 says.
There is 2 and 3.
We'll go on to the second and third as we go on.
Do they arise? That's the power of delegation.
And so on.
Yeah.
So,
Yeah.
in the midst of all this, this is the position that the Controller and Accountant General has taken. Bob Johnson is private legal practitioner. He's also going to be joining us on Zoom in a bit. But, Martin Kwebu, you are one of a number of lawyers who have asked the Controller to resign if he wants to still go ahead with his ambition as a parliamentary candidate for the NPP in the Achimsuru constituency. He's replied to you, says, you know what, I'm not going to resign based on these laws. Is there any legal justification for his position based on the details of this law that he references?
Not at all. Not one that so far my legal researches have revealed. Okay? Not at all. You know, I mean, we'll be objective. If the law protects him, why not? He should quote it. But unfortunately, what is quoted is strange. I mean, I'm being very charitable. It's strange. Why wouldn't he seek a proper legal opinion? That's why there are lawyers. Did he just say that no civil servant is appointed based on 195?
Yes.
Yeah, the seven. you know, this controversy, we've discussed this maybe at least a fourth time. This thing has been around, we've been having this conversation for at least 6 weeks or so now. And he can still make this statement. Let's go straight to section 52 of the Civil Service Act 1993. Look, here, listen. The power to appoint persons to hold or act in an office in the civil service is vested in the president in accordance with Article 195 of the Constitution. Why would Mr. Queenie do this? I mean, public office. Big man.
Read that again.
Why would he? It says the power to appoint persons to hold or act in an office in the civil service is vested in the president in accordance with Article 195 of the Constitution. Then 53 talks about the delegation, and delegation is also provided in the same Constitution. That's Article 195, Clause 2. Yeah, you go on and on. When you read the Civil Service Act, there are other provisions. So this is let's just continue. We should ignore it. It's like a joke. More than 6 weeks on. If it were even the first week, I would understand him. Then let's come quickly to the second point. He says because he's appointed under 195, so he's what do you call it? He's not a civil servant. You know, 195 is for all public servants, all. And the list of public servants is not even exhaustive. When you go to Article 190, you see the list. Maybe we should just run through a bit. Oh, fortuitously, when you go to 190, the first to be mentioned there is what? The civil service. So what I'm saying is that, let's do a little bit of mathematics. If you take the public service as a universal set, there are subsets within the public service. So like you draw one big zero, within it, small zero, subsets. So, hey, civil service, you see, judicial service, audit service, education service, prison, parliamentary service, health service, statistical service, national fire service, customs, excise and preventive, now part of GRE. Internal revenue, yes, that's GRE. The police service, immigration service, and the legal service. Then it goes to, I'm interested in C. Public services established by this Constitution and such other public services as Parliament may by law prescribe. Okay? Yeah, so that's it. The civil service, listen, shall, that's clause 2, until provision is otherwise made by Parliament, comprise service in both central and local government. Yeah, okay, so subsequently removed some, they say. That's why now you have Clocksack and then the local government service people. Yeah, okay, so it's been separated.
I see.
Yeah, so that is it. It's clear. So what I'm saying is that civil service is part of public service. And 195 says that all offices in public service, so even the janitor, you remember in the course of the week we did this an interview on the Ghana Tonight. Even the janitor, that's those who clean the washrooms, the sweepers, cleaners, security, drivers, they are all appointed based on 195. But the difference is that because generally they are junior officers, the president doesn't sign his their letters. That would be too much work. So the power is delegated to the heads of the institution to sign letters for this and the junior staff and that. But in terms of law, the power is 195. Maybe for emphasis, we can read the 53(2), which is the same as 195(2). The president may, subject to clause 2 of Article 195 of the Constitution, delegate any of the functions under this section by directions in writing to the council or to a member of the council or to a public officer. So that's the delegation of power of appointment. That's 53. So my point is that the cleaners, drivers, etc., they are also appointed under 195. So when Mr. Queenie says that he was appointed under 195 and so he's not a civil servant, he has said absolutely nothing. He said nothing. He should, tread cautiously. We can't do this. How? Is that how to put up a defense more than 6 weeks on after this matter came up. It's shambolic, you see, and I dare say that the way he's going about it gives me fears that, hey, if a matter that concerns your own office, basis of appointment, you are getting it wrong, hey, then what kind of work are you doing there? But we'll reserve that for another day.
Let me bring Haruna, because in the end, you see, it is your political party that Mr. Kwene Bosompeme intends to contest as a parliamentary candidate. Have you been monitoring the legal debate on his decision, and what's the party's point of view on all of this?
Thank you very much, Ukansi. First and foremost, I would like to say good morning to your cherished viewership and good morning to my colleagues on the panel. Yeah. For us as a party, we know that there is a constitutional provision to whoever qualifies to be a member of parliament, and that is enshrined in the 1992 Constitution. If my memory is right, I think it is Article 94 of the 1992 Constitution that states emphatically how, or the procedure on who qualifies to become member of parliament. On our part as a party, we have stated this on the nomination forms as they were picked by potential aspirants who have subsequently been vetted to represent the new patriotic party as we inch into breaking 8 in the 2024 general elections. We have not seen anything legally wrong with regards to qualification or disqualification of persons who have picked forms in respect of the Controller and Accountant General. I have seen that you have quoted provisions that he's using to make his point. And I think that these laws that have been quoted are those that exist on the law books of Ghana, which is eminent in the 1992 Constitution. So if people think that he has flouted any of the laws, and I'm happy you said somebody is testing the law, and I think that if that is so, let's wait to hear from the competent court of jurisdiction to pronounce it. Remember, he's not a candidate of the party yet. He's in a competition. And I think that he has legal remedies to himself. And that is why he's speaking based on point of law. He has quoted part of the public financial management law, and then he has also quoted the 1992 Constitution. I believe that he's not speaking on his own. He has lawyers. And I believe that the lawyers has given him a good counsel. And I don't think that this should be used to frustrate his ambition to become member of parliament. And I've also heard what my senior brother is talking about, Martin Pebu. Yes, we can quote these laws as we see them, but we must be very careful not to pass judgment when we have these laws before us. We always have a place where we adjudicate on these matters, and I think that we have to give room to the courts to determine such matters. It is also public knowledge that we all know not all civil service organizations are public service organizations. That's how he says it is the superset. But there are people who are in the public services that contest for elections and not resign, as he quotes the provisions that appoint to disagree with the point of the Controller Accountant General. So the window is there and the courts are also there. People can always make appeal or petition or bring cases before the law courts to be decided on the fate of people who wants to take up leadership role, such as himself. And I believe that he is very competent enough to be able to have a true representation in the courts to make his point.
Oh, you said that there are people who still serve as public officers and in the public service and contest the elections. I wanted to find out which categories of people within the law.
Teachers
can do that.
Yeah, teachers. Yes, they are public servants. Teachers they contest, they go in, they contest, they still stay on their posts. And when they win, they decide to resign. And they are also in the public services.
But there's a Supreme Court decision on this matter.
Yeah, that's the versus AG.
But there is also a Supreme Court ruling relative to this particular.
Yes, that's civil servants.
specific to civil servants.
Yes.
That's the Clocksack case.
Yes.
The Clocksack versus the Attorney General and 2 others. What was the Supreme Court's directive or conclusion, the ruling on that matter?
Oh, that one, the Supreme Court is very clear that the day a civil servant makes overt his political affiliation, he should immediately resign. That's the where the Supreme Court is. They said immediately. It's not like 1 week or 1 month. No. If it's on political grounds, that is to say that the person reveals his political affiliation. I belong to party A, party B. Then he say immediately go. There is no time for 1 week, 2 weeks. No, you can always resign and send your handing over notes later. That's very clear. And the Supreme Court went over and over and said, among others, 1, we are still developing as a people. Okay, so our political maturity is still, coming up, right? And so usually, as soon as you overtly show your political colors, sometimes it leads to disagreements and violence. So we don't want any such risk in the workplace. And most especially that the civil service is supposed to be neutral, impartial, among others. So as soon as you show your political colors, then the neutrality is thrown out of the window, you say. So that's another reason why listen, as soon as the political colors are out, the person should go. Then they also mention corruption. Yes, corruption, that it will breed corruption, because once you show your political colors, yes, then the politicians, you know how they do. Of course, we know that it exists where they do it secretly. But, certain things, well, little by little, we'll get there. But if we allow it so openly, that's going to be another problem altogether, you see. So maybe we should read, that's page 224 of the Clocksack case. It says, moreover, so talking about a person who has revealed his political affiliation. Moreover, such a person shall resign from his or her office immediately his or her political activities become overt. So you can be any party member quietly, secretly, but the moment at the workplace, it becomes clear that you say you are for A or for B. It says immediately leave.
So that position that he is not a civil servant because he was appointed under the PFMA and then Article 195, that has no basis. It cannot be the justification for him, as he made reference to in the voice that we just played.
Because he said he's not a civil servant.
Yes, and when he said he's not a civil servant, he made reference to these 2 laws.
Yes,
195 and PFMA.
195, as I said, is for all public servants, including civil servants. And we've shown that even his categorical statement that no civil servant is appointed pursuant to 195 is false. That one is very clear. He said it, right? And we've shown 52 of the civil service law.
But also, come to look at it, perhaps his terms of engagement might be different from the other people that you are also aligning it to. So if his terms of engagement is different, definitely he would have the right to say that he's not a civil servant, in line with the persons that have been appointed together with him.
Let's go briefly a bit more into it. You see, when you go to Section 8, as I said, we are all trying to be very objective. If there was any law, I think by now, any law that categorically exonerates him, with the thousands of lawyers we have in Ghana, nobody would have brought it out. I've been reading and reading. That's how come yesterday I just took my time to read the whole of the Civil Service Act again to see whether there is anything. If you read the Civil Service Act, they are very clear. Look, they say, you see, let's look at this. The, what do you call it? The Controller and Accountant General, his office where he is in charge, it's a department. It's a department. Department of what? It's a department as part of Ministry of Finance. You remember earlier in the week, just briefly so that we go to new points. Earlier in the week, we showed that under Section 8, after saying he is appointed under 195, when you go to 3, subsection 3, it tells you how the Controller and Accountant General shall be responsible to the Minister for the custody, safety, and integrity of public funds, And then they go on and say other things. He keeps books, accounting books. It's a civil service job. All his subordinates under him, civil service. He keeps books, money, and then our money and all that. We can say, let's go on. If you read the Civil Service Act, okay, it tells you that people that they don't want to call this, what do you call it, civil servants, they make clear. They will tell you political appointee. So you see the minister, chief director. Then they tell you chief director is a public servant. When it comes to the directors of the ministries, then they say, look, these are civil service jobs. These are civil service posts. So where they mention who is a political appointee, then they mention chief director just being a public servant. Then they come to directors in the service. They are they are civil service posts. Clear. So when you see 195 doesn't exonerate you. Then every cleaner, every driver is also appointed under 195. You see the point. So
my lawyer.
And then let's go briefly to this. Some history. You can double check. Before Mr. Queening came in, I don't know, either directly before him or before, in the GM administration, there was a controller called Seydou Kotoma. Now see how it shows that by practice they are civil servant. Because Akufo-Addo didn't want to work with him, they removed him. The one who was controller under this in GM's administration is called Seydou Kotoma. They removed him. Where did they take him? To another place in the Ministry of Finance. Another place. Then look at another example. Then there's a man called Kojo Flynn. He was administrator of the Common Fund, District Assembly. Because he is not a civil servant, when they didn't want to work with him, they removed him and he went home. They paid him his entitlement. But Seydou Kotoma, who was a controller, when your people didn't want to work with him, they removed him and took him to another place in the Ministry of Finance.
But it's not an established fact that they didn't want to work with him.
I haven't given reasons. Yeah, no, I said if they don't want to work with, I've not gone into
it's not
reasons.
established that they didn't want to work with him.
Okay.
It was within the right of the civil service or public service to transfer, or repost staff to where they are needed. But the reason asserted by you, it's your own reason. Okay, but Akufo-Addo has never, or our government have never.
I'm not mentioning some ways. I just said we'll not work with. I didn't give reasons.
Yeah, but I was making a point that you take. Let's go to the Youth Employment Agency. It's a public service organization, which is not civil service. You go in there. There is a controller staff who has been posted there as the finance director. You go to National Youth Authority. You go there. They are a public service organization, not civil service. But you go there, you see controller staff that has been posted there. So perhaps the terms and conditions of his engagement of posting him to the Controller and Accountant General based on the laws that he has established, that is the PFM law, and then the Article 195. Perhaps his terms of condition is different. That makes him not to be a civil servant. And that is why I said that we can test this in the competent court of jurisdiction.
And that he will be buying time.
So you want
time.
But lawyers always do that. You buy time in court always. When you know that you have a bad case.
You want the matter to be tested in court. You want some sort of an interpretation of the court on this matter before the party takes any decision.
And for the party, we have not done anything wrong. We have open nominations, all the procedures that we have taken him through, looking at the various articles that gives the right to people to contest. He has not flouted any of them. If it is established that he has gone against a provision in the Constitution of the Republic of Ghana, or he is culpable of a certain act, then the party will be able to take action on certain matters. Until then, he is qualified enough to stand to contest.
But if the party is not concerned that maybe after all things being equal, maybe just for the benefit of analysis, if he wins, this matter will still be lingering on in court, and instead of the party concentrating on its work in the constituency, you'll be going to court battling this matter. You're not concerned about that?
This is a decision that National Executive Body has to take. And the National Executive Body has so decided that these people should be given the opportunity. Remember, vetting has just concluded. Reports of vetting has been submitted, and these reports will go before National Executive Committee. Appeals have been made. Nobody has made an appeal against him, and appeals committee will not be hearing. Appeals ended yesterday, and then appeals report will also be submitted on Monday. On the 17th of this month, National Executive Committee will meet to take decisions on these matters. And this has not been brought to their attention, unless, of course, maybe on the 17th, if something like that has been brought to the attention of the National Executive Body.
Well, I'll come to you, Ms. Bebo, in a bit. But, Professor Jampo, I mean, this is a conversation that it's not the first time we're having. The new twist is that the controller himself has responded, that he's not going to step aside. He's going to go ahead regardless of the legal issues. Right now, Nelson Rosenthal is in court on this matter. We would look at the reliefs he's seeking. But this is the position of the controller. I am not going anywhere. I will contest. I'm not a civil servant.
Good morning.
Morning to you.
Give me 2 seconds to do something. Mr. Kofi Bentum Kwansen, good morning to you. At one time, I think National Security Advisor or something, he just sent me this book. The security in the hands of God. And then also bogus informants, nation wreckers. Sir, morning. I am grateful. And this is touching. Prof, this is my quick way of celebrating you. Fly higher and higher, son of Ghana. Thank you very much, sir. I'm grateful.
Well, I was hoping we will reserve it as we end, because I got that gift as well.
To you, by grace, may the spirit of the universe protect you, and may your ancestors be with you. Thank you very much, Prof. Mr. Kofi Bentum Kwansen. I'm very, very grateful.
That's right.
Coming to the issue on the table, the Akans have a proverb that se okusi se obenante kwantempon so a onimrika no wakukudru. Se okusi se obenante kwantempon. If okusi is what in English? If okusi says he will walk on the highway, if okusi says he will walk on the highway, it's either it is brave or it has speed, it can run. Because as for okusi, if they are chasing you, have to be dodging. But if you want to be on the so I want to believe that Mr. K.K. Bosompem knows what he's talking about. We all came to sit here earlier. I mean, I was so angered when we heard that he's a civil servant and he was running for a position, and we felt that given to what had happened to previously, to other previous civil servants, he should have just done the simple task of just going away. But now he's come back to throw certain things at us that, in my view, should force us to think, think deeply. Otherwise, we should think deeply and then do the right thing to bring about clarity. You see, before the civil service laws of Ghana were formulated, somebody had already given his ideal type formulation of what the civil service should be. Okay, so the civil service and how it should operate had already been given by a German sociologist we call Max Weber. Okay, he gave his ideal type of the civil service and said that the civil service is supposed to be the administrative machinery of the state. Now, to be able to function effectively, see, if the features of civil service, as I'll go through shortly, are respected, then the civil service should be able to run the nation even when political parties or presidents or government have not been formed. Because it's supposed to be the administrative machinery, of the state. And so, because of that, he says that recruitment, transfers, promotions, and demotions, and all of these about the civil service should be done based on what he refers to as meritocracy. It means you must merit to be there. That is how come I have a little problem if you say that if we extend or expand interpretations that my colleague Martin Pebu gave, that all civil servants are appointed by the president. Because we know that presidential appointments are not always or necessarily meritocratic. Okay, it will be a civil servant, you should go through a certain competitive selection process. You should write exam, you should go for interview and all that, and if you merit it, you are given. Now the other
feature is that they should be competent. If you are, of course, selected through a meritocratic process, then you should be competent. Then they have what we call security or stability of tenure. Once you are appointed, you stay in office till you retire, subject to good performance, and if you perform well, and then also you don't involve yourself in anything that would make you dismissable. I mean, you are supposed to be there till you retire. Then they operate under the cloak of what you call anonymity. Anonymity here simply means that they don't take praise, they don't take blames for whatever they do. Now, so if they work very well, is their top appointee minister who takes the praises. If they don't work well and they don't perform well, it is their minister who takes, or their head who takes the blame. And then last is about this political neutrality thing. Now, so when Max Weber spoke about political neutrality, he didn't mean that bureaucrats or civil servants shouldn't vote. All that he said, or all that he meant, was that to be politically neutral, you can have the right to vote, but you should not openly be seen to have identified yourself with party A or party B. You should not be seen to be adorning yourself with party paraphernalia. You should not be seen at party rallies. You should not be seen at electioneering campaign of any party. You should not be seen to have gone to pick a nomination form to contest on a ticket of a political party. That's what is there. These things were there before we formulated our laws. Okay. Now, so we here are trying to subsume the civil service under the public service. Now, in trying to do that, you see, then we can see some contradictions. So now we are saying that some members of public service can do partisan politics, but some within the civil service cannot do partisan politics. It creates problem. I believe that public servants are supposed to serve all of us, regardless of our partisan coloration. So if so you are a public servant, I am MPP. I am a public servant, I'm MPP, you are NDC. Should that affect how I render service to you? Okay, so I believe that if the ideals of political neutrality are to be cherished, then this ideal must apply to both public servants and to civil servants. That's why, as a lecturer, I have a problem with some colleagues who will go about openly to say I'm MPP or NDC, because a lecturer, I'm a public servant. And I grade scripts of students, okay? And I give advice to students. I do all manner of just to help students. It should not be seen, or it should not be seen that I am NDC or MPP, and so my students who belong to other side of political divide are not comfortable and they cannot come to me. I believe that if the ideal of political neutrality is to be cherished, it must apply both the public servants and to the civil servant. Now let's come to KK Bosompem. Now he's mentioned it clearly that, look, I am not a civil servant. I am a political appointee. Now, so when I heard this statement, I started pondering over it. So if you say you're a political appointee, then I think he's seeing himself in the ranks of, if you like, a minister or an appointee.
Did you use the word political appointee?
Yeah, he said he's not a civil servant, he's a political appointee.
He says he was appointed by the president.
Yes,
But he didn't say he
because
was a
under the civil
political
service, or when you say political appointee, then they've not mentioned
the president.
So let's use that word. Because everybody is appointed, everybody in the public service is appointed by the president. So once he hasn't said political appointee, maybe
he said he's not a civil servant. But he didn't say he's a political.
He said he's appointed by the president under 195. And we're saying
but
for all public.
if you're appointed by the president, then can't we say a political appointee?
No, that's why I say.
Then equally, you say the chief justice is a political appointee.
The sweepers, what do you call them, drivers, they are all under 195.
Well, okay, so the point I want to make on this particular issue is that, you see, making that daring and audacious statement mean, as you indicated, my brother, as you indicated, that it means that he knows what he's doing, and like that. So that fits my proverb that I give, that okusie se obenante kwantimponswa unimirika no akukudru. Okay, maybe some lawyers are advising him. Maybe he's read the laws and he feels that, well, under this particular under certain particular provisions, he is able to do what he's been asked to do. And I'm told that he's a retiree, and he was asked by the president to stay on. I want us to be fair, objective, and level-headed in looking at some of these things. A civil servant must be politically neutral. If you approach the age of retirement and the president says continue to serve, does that give you the leverage to be able to go into partisan politics or not? I think we must begin to interrogate some of these things so that we don't confuse ourselves, so that we'll have finality to an issue like this. And it is important for us to appreciate the fact that per the level he is not too, you cannot put him on the same pedestal with other junior civil servants. Okay, because this one, he was due for retirement and he was asked to stay on. So he occupies a certain position that makes the whole thing, confusing. But I believe that the principle of political neutrality is a tried and tested principle that if all civil servants would adhere to it, it would help so that the civil service will continue to serve as the effective administrative machinery of the state. Because this principle of political neutrality is not being respected, that is how come you have the civil service not operating and working well. Because if NDC comes to power, they believe that the civil servants there are not politically neutral. They would sabotage them. So what they do is that, yes, you would continue to staff the civil service as workers. You continue to work. We'll pretend we are paying you, but we pay you pretense, but we'll not make use of you. That's how come when the MPP got to power, this is what they did. The civil service is working, but they didn't trust them because they feel that they were staffed by MPP appointees.
NDC.
NDC appointees. And so what they did was that they created a civil service, our civil service within the civil service by appointing advisors, consultants, chief advisors, advisors to the consultant. You create all these offices, and one advisor to the consultant, his salary may pay about 100 civil servants and all that. All these things are a drain on the nation. They don't allow the civil service to function effectively. And if power changes hands, the next administration sees the civil service and say, look, these people, they are all MPP appointees. Either we find a way of relocating, transferring them, making them inefficient, or we also would add hours, appoint our own people and place them there. So oftentimes, the civil service is over-bloated, and it is staffed by people who cannot be described as competently delivering on their mandate to ensure that the civil service, performs, serves its purpose as administrative machinery of the state. So, Mr. KK Bosompem, like I said, this matter must be tested very well in court, a specific matter. I think it will not hurt if we go back to court to seek a legal opinion. And I'm happy that someone, Dafia Makpo, I'm told, has gone to court.
Yes.
Let the court processes decide, and let us bring finality to that. But I repeat that the idea of political neutrality on the part of civil servants is important in ensuring that the civil service effectively deliver on its mandate as administrative machinery of the state.
Indeed. Thank you, Professor Jampo. And this matter about going to court is what it appears the MPP even supports that. With what Haruna is saying, let the matter be tested in court. And let me also indicate that we had advertised George Kwekuru Hagan, the Cape Coast South Member of Parliament, the ticket of the NDC, was going to be joining us. We understand he's had a medical emergency this morning, and unfortunately he cannot join us. So that's just to put it on record. We are following up to find out exactly what's happened but that's the information that we have gotten. Thankfully, we have the Director of Legal Affairs of the NDC. He's a private legal practitioner as well, Godwin Eduji Tamaklo. Is joining us on Zoom. Counsel, good morning, and welcome to Key Point. If you can unmute for me.
About this way.
Sorry.
Hello?
Can you hear me?
I can hear you clearly. No, unmute.
Yes. Can you hear me?
I can hear you clearly now.
Fantastic.
Thank you for joining
So
us.
I was saying that good morning to yourself and good morning to your cherished viewers and the esteemed panelists.
Great. Thank you for joining us. Also joining us is private legal practitioner Bobby Banson. He's a lecturer at the Ghana School of Law. Call it Makola. Lawyer Bobby Banson, good morning. Welcome.
Good morning, Alfred. Good morning to your viewers and to your panelists in studio and joining on Zoom.
Great. Thank you. Thank you very much for joining us. Now, the last time we spoke, Lawyer Bobby Banson, you had indicated that you were surprised that nobody had even drawn the Controller and Accountant General's attention to the fact that legally he might not have the law on his side. Well, he's had a direct reply to you that, you know what, based on the law and my understanding or his understanding of it, he hasn't done anything wrong. He's going to contest.
Well, I think that I was following the cue from Senior Martin Pebu that time in studio, so maybe the reply was directly to him and the rest will come to the small, those of us who were behind the scenes. But I heard his comment. I think that I'm still stuck to my original position. Fortunately, like it's been taken to court. If the rate is able to surmount technical challenges or procedural challenges and sees the light of day, it will be interesting to see how it will go. I hope the question is whether or not it will be determined before either the primaries or the elections. That is what I'm thinking of, so that we'll have a situation where, just like in the Jachi Kwesin case, whether there will be an order for injunction to restrain him pending the determination of the suit or not. It's very interesting how it will stand out. But because it's in court, you are careful the kind of comments you pass, so you will not be deemed to be prejudicing the outcome of the court case. So I'm happy at least it's gone to court. If it sees the light of the writ, then we can see how it will be interpreted and applied, so that it will guide all of us to avoid any form of confusion. Like it's been said before, when I joined, I think that it's a wonderful submission. For example, you cannot say that a high court judge was appointed by the president and not nominated by the president to go through parliamentary vetting. So a sitting high court judge can go and say that he's running for parliamentary candidate on the ticket of any political party whilst he's a sitting high court judge. If you go by parity of the reasoning by the Controller and Accountant General, then it will permit, for example, a high court judge appointed directly by the president to say that, well, I didn't go through the parliamentary vetting to be appointed, and so I can go there and go and stand for member of parliament. I think that there is a reason why these persons who occupy certain sensitive positions are expected to maintain that level of neutrality. Like it's been said, they are not barred from voting, but at least you cannot publicly express your allegiance to one political party or not because of the sensitive nature of the position that you hold. So let's see how the court would interpret and apply the law to the facts in this particular case.
Indeed. And let's go to Nelson Ross in Dafiamekpo's suit and the relief that he's seeking in there. And I'll bring Lawyer Eduji Tamaklo at this point on this matter. Because as we do know now, that he actually turned, that's the Controller and Accountant General, Kwesi Kwenim Bosumpim, from the information that we've gotten, turned 62 years last year. And it's still on. In fact, as Lawyer Martin Bebo, you indicated, it's on contract. Whether that also changes the dynamics of this case is another matter. But these are the reliefs being sought by Roxanne Nelson Dafiamekpo. A declaration that the defendant is a civil servant and therefore cannot contest in the NPP's parliamentary primaries while holding office as the Controller and Accountant General. 2, a declaration that the defendant as a civil servant can only contest in a political party's parliamentary primaries if that civil servant has resigned from his position as a civil servant. 3, an order of interlocutory injunction restraining the defendant from holding himself out as the Controller and Accountant General while he still maintains his candidacy to contest in the NPP's parliamentary primaries to be held on January 27, 2024. 4, an order of perpetual injunction. So there's an interlocutory injunction he's seeking and a perpetual injunction restraining the Controller and Accountant General from holding himself out as the Controller and Accountant General while he still maintains his candidacy to contest in the new patriotic party's parliamentary primaries to be held on January 27, 2024. And also an order directing the defendant to resign from his position as Controller and Accountant General if the defendant insists on contesting in the NPP's parliamentary primaries to be held on January 27. And it appears that, Lawyer Duji Tamaklo, this matter of this being tested in court, even the NPP supports that. Now, following this conversation till this point, does the law have any place for Kwesi Kwenim Bosompem's ambitions while still a sitting Controller and Accountant General?
Okay. So once again, good morning. I want to start my response to your question by looking at a statement that a U.S. political commentator made. And this is what he says. He said, all democracies, all democracies are fragile. They depend on political leaders who believe in them and put the Constitution and the rule of law above their personal ambition. They depend on media that tell the truth. They depend on citizens who are intent on retaining their rights and freedom, who feel deep allegiance to democratic norms and who refuse to follow demagogues, unquote. The reason why I decided to preference this is that, you see, the Bible says that all things may look lawful, right? But not everything is wise to do. I was expecting that the controller would demonstrate some self-restraint by voluntarily having taken the decision to contest in such a politically sensitive matter to resign. But I want us to carefully look at what the position of the law is. Regrettably, there has been some confusion. And this confusion, regrettably, may be coming from maybe the court itself. Why do I say so? In the many years ago, around the year 2000, some chief directors decided to contest NDC parliamentary elections. The chief directors of energy, Ministry of Energy in the year 2000. So the NPP quickly went to the Supreme Court in the case of NPP versus NDC, because at that time, it's the NDC that allowed those individuals to contest its parliamentary primary. So the NPP sued NDC in the Supreme Court. The Supreme Court took a position that since reference is made to Article 94, you can only start the challenge if the Electoral Commission opens up nomination. And so that matter didn't really go far. And that became the basis of my position when the senator matter came up. Then the Supreme Court again had the opportunity, PCRP Ofori versus Attorney General, then Auditor General, against the then Auditor General. Now, in that particular case, a distinction was drawn between two sets of public servants, and here not civil service per se, because the position of civil service is open and shut. In the reported case of, it's unreported now. I just want to reference the suit number properly for the purpose of this discussion. I put it. So the Supreme Court in the matter of Civil and Local Government Staff Association of Ghana, CLOGSA, versus the Attorney General, Office of the Head of Civil Service, Office of the Local Government Service. This is a Supreme Court decision dated 14 June 2017. The Supreme Court, speaking through her ladyship, Sophia Akufu, made the point clear that as far as civil service or civil servants are concerned, they are completely forbidden from engaging in active politics. No exception. And if you look at the conclusion, he said, conclusion, consequently, we determine the issues set out in the memorandum of agreed issues as follows. Quote, on a true and proper interpretation of the Constitution, a member of the civil service or local government service has a right to join a political party of his or her choice. However, such a person does not have the right to participate overtly in political party activity while still a member of the civil service or local government. So the decision of the Supreme Court on this matter, as far as a civil servant is concerned, is foreclosed. It leaves no ambiguity whatsoever, right? Now, the same Supreme Court now proceeded by saying, quote, on a true and proper interpretation of the Constitution, a member of the civil service or local government service does not have the right to contest for election for political office or hold political office while still a member of the civil service or local government. Now, even more intriguing, germane to the specific case of Mr. Quatin. This is what that's holding three. On a true and proper interpretation of the Constitution, a member of the civil service or local government service does not have the right to remain a member of the civil service or local government after his or her nomination by a political party or otherwise to contest for election as a member of parliament. Moreover, such a person shall resign from his or her office immediately his or her political activity becomes overt. So in the specific case of civil servants, the Supreme Court has clarified that position as late as June 2017. So that is not in doubt. However, if you look at the point canvassed by the controller, he cleverly said that I am not a civil servant. Mm-hmm. I am a public officer. Right? Mm-hmm. Now the question is, this decision of the Supreme Court relative to civil servants, does it apply with the necessary modification to public office holders? Now, the Supreme Court in the PC appeal for redecision tried drawing distinction between certain categories of public office holders. So if you note, they are public office holders appointed pursuant to Article 194 and Article 195. Those categories of public officers, are they foreclosed from overtly doing public servants? The conclusion is yes. Mm-hmm. Can the controller or the auditor general, who is appointed the same procedure as the controller, mount a political platform? Certainly no. Because of the sensitive nature of your work. The controller, just as the auditor general, provide a key countervailing force in public finance administration. Now, if you have such a person overtly doing politics, it undermines the office that he holds. And so this, and remember that if you look at the Constitution, and he himself referenced that his appointment is pursuant to Article 195. You heard him, Alfred.
Yes.
You heard him.
Yes.
Now, a person appointed under Article 195 cannot do overt politics. The special prosecutor, the office of the special prosecutor, if you look at the memorandum, and in fact, if you read the parliamentary debate, Afenyo Markin, in contributing to the conversation, said this office is made pursuant to Article 190 and it flows up to 195. Now, can the public prosecutor mount a political platform? Certainly no. He doesn't even need law to tell him. What he needs is common sense. You understand?
I see.
He doesn't need laws. He needs common sense to tell him. Because you see, what is the job of the controller and accountant general? A very sensitive, countervailing force in our democratic system to ensure that public funds in a proper manner. And so if you read the PCRP of Ori, look, do you know that the controller, unlike other public servants, cannot even be removed by the president unless on stated grounds? So in PCRP of Ori, for instance, the Supreme Court had to import the provisions on the removal of Supreme Court or Superior Court judges to apply mutatis mutandis to that of the Auditor General, because there was no specific provision. There was a lacuna, there was a gap, and the Supreme Court imported that provision and said, look, the sensitive nature of the work of the Auditor General requires a certain insulation from political interference. If, for instance, the controller, the finance minister presents a particular maybe bill for payment or warrant for payment to the controller, and the controller, based on his work, vets the payment and said, look, this payment, I will not allow this payment to go through. If you allow the controller to just be anybody that can just be removed at the whims of the president, the danger is that a finance minister who is overbearing can easily get him out and bring someone that he can basically control and destroy public finances. And so in the superior wisdom of the Supreme Court, in the specific case of the Auditor General, they imported these provisions, that's Article 146, into the provision for the Auditor General. I want to make the submission that in the specific case of the controller and the important role they play in public administration, he may not come across as a civil servant, but he comes across as a public servant whose work has already been categorized by the Supreme Court in the PCRP of Ori decision, whereupon the Supreme Court made it abundantly clear that regardless of the name, whether you are a public of, what is important is, and in fact, Justice Atukba, in the case of Agbavo versus the Auditor General, make the point that the qualifying criteria is the work that you perform. What work you perform? If it's a public function, then you need to demonstrate a certain level of political neutrality. Do you know that the controller may fall under the category of Article 70 office holders and 71? And therefore, his office is a very specialized office. And that is why, excuse my language, you don't put a medical doctor to be your controller and accountant general. It requires a certain skill set, which skill set falls directly under the 1992 Constitution and the preamble, transparency, accountability. And that is why his name is what? Accountant General. To ensure public accountability Now, if you are to ensure public accountability and you are an MPP person, no, overtly, you destroy the public finance of this country. So at this point, what the gentleman needs is common sense. He needs common sense.
Right.
To dictate to him that his function is so critical in this democratic experiment. And like I told you earlier, referencing the American political commentator, democracies are fragile.
Right.
Democracy has the mechanism to kill itself. And that is why democratic governance requires persons who should demonstrate self-restraint when it matters most. I think this man definitely lacks it.
Well, we'll see. But so long as this matter is being tested in court, beyond the appeal you make for common sense to prevail.
You see, the challenge is that, and maybe I have to make this point. Okay, so the Electoral Commission decided, I'm just drawing parallel. The Electoral Commission decided to do registration of voters. I lead a certain people as their lawyers. We went to the court. We filed an injunction application, right? And the time period for the election was so and so. It was during the vacation. But a date that was given for us to move our injunction was 17th October. The exercise ended on the 2nd day of October. So the question is, by the time the court was ready to hear us, the very exercise we were seeking to restrain had died, quote unquote. I am saying that, yes, my senior Roxy Tafiamako is in the court. Is it one of the matters that will be handled expeditiously so that a certain clarity is brought before the 2020 election? And in this particular case, the MPP is having their parliamentary primaries, I should think 27th or so.
Yes, 27th.
Good. What would we have a decision before 27th, which is barely 2 weeks? So, like I said, sometimes the person who is at the center of the storm himself must demonstrate that he's not doing this democracy any good with this posturing.
Okay.
Because the judicial outcome may come when the horses are bolted.
Right. Well,
Why does he think that the outcome will come when the process is
maybe based on the precedents that is used. But,
yeah, but I think in the case of the Judge equation matter, the court suddenly saw the urgency of the matter such that then at one point in time they were going to hear the case, on a daily basis. And so I think that court.
I think that so that Prof doesn't confuse the two things. In the specific case of Judge equation, it's a criminal trial. It's not a process at the Supreme Court. So you shouldn't confuse the two. Right. It's a high court matter that requires trial. Evidence will be put. Witness statements are found. Prosecution will leave evidence. Defense will come in. That's entirely different.
But lawyer, I don't think we are also saying that our judges should not be responsive to the agencies, of the time. It may be a criminal case, and for that matter, you may want to be sitting on a daily basis. But if there is an issue of national agency, should we allow judges to detect and say that as for the access of the justice process, it grinds slowly? I think that's a bogus understanding and belief that, and we have pampered some judges too much. Issues that requires timeous delivery of justice must be addressed as such. Justice delayed is justice denied.
Prof, you were in this country when the political parties issued a writ, applied for injunction. A date was given in October 17th.
No, I agree with you, but I'm saying we should not. We shouldn't pamper that.
Look, you see, listen, Prof, I beg you. What I want is, if within 2 weeks this matter will be resolved, clarity will be brought to it. Hallelujah.
Yeah, so let me make a point, a quick one, just to make. So in the Domlevo case we took to the court, the Supreme Court realized what had happened, this problem. They stated that the rules of court should come out with new rules on this and such expeditious trials. So maybe what we should be pushing is that the rules of court, since the decision came out, the actual decision copies we got in June, what has the rules of court been doing?
No, but I agree. Even before we talk about the rules of the court,
yes,
taking into consideration the number of days to
he wants to make a point.
Yes. While I conclude on this matter, yes.
Alfred.
Yes.
Alfred.
No, I'll come to you.
Yes.
Alfred.
Yes.
A quick one to Senior Kwebu. You see, Senior Kwebu, we can't hide behind rules of court. See, in 2012, on the creation of the 45 new constituencies, I was then in the law school. My law lecturer, company law lecturer, the distinguished geographer, issued a writ challenging the creation of the 45 new constituencies. He issued a writ September. By the 19th of September, during the legal vacation, the Supreme Court had heard the injunction because the then Chief Justice George Nawood empaneled a sole justice of the Supreme Court in the person of Justice Julius Ansah to make a determination of the injunction. Within a week, the injunction was heard and decided.
So it is possible.
Within a few months, the substantive matter was heard. So it's not a matter of rules of court. Please.
Okay.
I think that this matter is not a matter that we should be debating so much because we've all admitted that it's before court, if indeed it has been filed. In his preamble, he has also indicated that there is two strands to this particular matter. He quoted Article 94, and he made reference to the time of filing at the Electoral Commission. This is still a contest he's going through. If the court decide anytime soon or later, will still not have so much effect on the decision that is made by delegates at the very constituency he's contesting. The window of change or the window of replacement is enough to the new patriotic party should in case he gets elected and a court decision is made. It should not be crying more than the beef because we are the political party. We are not seeing it as injurious enough to affect our chances.
No.
But
we are wrong on that score. He's still the controller of the republic, not MPP republic. You are getting it wrong.
But you are not the controller of the new patriotic party, so I can't be wrong on your question.
Today you
No.
calm,
You see, the concern is not about any other person contesting MPP primaries has not been a subject matter of conversation.
Indeed.
The conversation is that in the specific case of this man, he is not the finance director of MPP.
But he says he's not a civil servant. He said he's not a civil servant.
The fundamental issue here.
He is the controller of the Republic of Ghana.
That is not in doubt, but he said he's not a civil servant.
In fact, that's...
If he's handling MPP finances, we don't care.
Well, so that's the most...
But the point is that, Ejudi, what you have to note is that he said, the person that is in this contention said he's not a civil servant.
Well, that's the statement
we have been... the fact that he's not the controller and accountant general. But let's take to the facts and let the court decide on those matters.
But I think that we also would also agree, take into consideration that we're even having this discussion because it is not just about him as a person. It is the particular position that he occupies and the fact that it goes beyond the new patriotic party and the functions that his office is expected to, as it were, execute. Being the accountability agent of government, for that matter, of the people of Ghana. That's where the concern is. But let's